As you're coming in, I want to welcome everyone to this emergency conversation to discuss what really is a truly, truly shameful bill. It's called the Illegal Migration Bill, but, first off, let's remember there's not some pre-existing category of illegal people who migrate, but rather people are illegalized by borders. And as we listen to our speakers, you're going to learn more about it. But what we're seeing is effectively an end to the asylum system and a vicious attack on people who've come here post-March and future would-be, March the 7th, and future would-be asylum seekers and future victims of trafficking and modern slavery, and on their family members, including future children. But I think it's also a really vicious attack on the futures envisaged for people living more generally in the UK. I mean, what kind of country are we making here? What happens to all of us when we make this kind of cruelty and injustice tolerable? And the unworkability of these proposals, I think, really risks leading to more undocumented people, more exploitation, more abuse, more criminalization, and fomenting racism, which doesn't care about the documents you're carrying. So we've got three aims to this event. Firstly, that we inform ourselves about the bill and its implications. Secondly, that we share ideas about what can be done in response. And thirdly, that we open a conversation about the role of academic research in an environment which is increasingly hostile to migrants and anyone who supports them. So we've only got an hour, so I'm going to ask you to think about your comments and questions in relation to one of these three aims. So I think Emily's put it in the chat, says bill and its implications. So if you know something that you think is really important and want to share it, please do. But if you've got a question about the detail of the bill, and I think that the answer is in the resources on our webpage, then I'll point you to the page. And more generally, I'd really encourage people who want more details, more in-depth knowledge, to look at the resources on that webpage. So that's the first aim. Second aim, what can be done? I mean, we know this is awful, but it's not enough to point out that it's awful. What are we going to do? And I really think any ideas you have about that or any initiatives that you know are underway, please, again, put it in the Q&A and we can share it more generally. Finally, the role of academics. How is it that we've got to a place where more and more people are researching migration and the political debate is getting worse and worse, and what can we do about this? That's a big question, and I think people might balk at it, getting it started here, but any ideas, or even if you're just interested, please let us know, and again, put that in the Q&A and we'll gather it together. So there's a lot of people coming, so we're running this as a webinar, and you'll need to use the Q&A function. So and then I'm going to put the questions, or an amalgamated version of the questions, to the speakers. We're going to be recording the event, so I'm not going to give the name of the person who commented or asked the question unless you specifically ask me to. If you want me to, I'll use your name, otherwise it will be an anonymous question. So now to introduce our speakers. Our first speaker is going to be Colin Yeo. Colin is a barrister at Garden Court Chambers in London, and he edits the Free Movement Immigration Law blog, which he founded in 2007. Really recommend that you take a look at that. He's the author of Welcome to Britain in 2020, a general interest book exploring and analysing immigration policy over the last 25 years, and a textbook, Refugee Law. He's currently working on a new immigration law textbook, and he's an MMB-sponsored honorary senior associate in the Sociology and Politics School here at Bristol. Second up, we have Anne Singleton. Anne is the MMB strategic lead on migration policy and an expert in the use of migration statistics in policy development. She aims to inform public and policy understandings of human mobility and migration, and her work includes reports on deaths during migration. She sees the illegal migration bill as an example of evidence-free policy produced without due process, checks or balances, and in the absence of evidence or human values. In the broader context of EU and UK policies, she believes it represents a serious threat to the civil liberties of the whole population. And finally is Andrew McCarthy. He is Head of Services at Bristol Refugee Rights, BRR. And for those of you who live in Bristol will know BRR is a fantastic organisation, runs many services, including a social drop-in and advice service, casework for those with complicated multiple needs, early years, a project supporting young people, support group for LGBT plus asylum seekers, lots of classes and well-being focused activities. And there was they wrote a really interesting and moving piece in Bristol Cable recently about the implications of the bill for their work. So each of these great speakers is going to speak for about 10 minutes and then we'll move to discussion. So I'll now hand over to Colin.
Thank you very much, Bridget. So I'm going to try and talk through what the illegal migration bill does, or at least what it's supposed to do, and how it's supposed to work in practice. If I've got time, I'll turn at the end to whether it might actually work in practice and what the problems with it might be. But I think I'll probably just leave that for the other speakers to address. So the basic idea of the bill is to deny access to the asylum system to basically anybody who arrives by irregular means. So all of the headlines have been about small boat crossings, but actually only about half of the people who claimed asylum last year arrived in small boats, about 45,000 people out of about 89,000 people who claimed asylum. So it would affect everybody who claims asylum after the 7th of March this year. Obviously, that's a date that's already gone past. It's the date that the bill was announced. And so effectively, the bill will be retrospective. So we know that 500 or 600 people have already arrived since the 7th of March by small boats. Others will probably have arrived by lorry or other means. And all of those people will be subject to the provisions of this bill when it comes into force as an act of Parliament. Now, in order to follow through on that policy of basically denying access to the asylum system, it literally outlaws consideration of their asylum claims. So the Home Office, the Home Secretary will not be permitted, according to this law, to look at their asylum claims. And then the rest of the bill essentially flows from that. So, for example, it includes a power to detain people. It's not automatic detention, but it's a very extensive power of detention with new legal quirks to it that make it very difficult to challenge in practice. And I say that from a lawyer's point of view. So the idea is that people will be detained and then they will be removed to a third country. And the only third country that will accept asylum seekers from the UK being removed to there is currently Rwanda. So the plan is that everybody who claims asylum will be detained under these new powers and then removed to Rwanda. And it's not that they'll ever be brought back. The bill also forbids the Home Secretary, other than in very narrow circumstances, from ever granting any kind of status to these people. And it even forbids the Home Secretary from granting citizenship to any children who are born in the UK to people who've arrived in this way, which is a genuinely extraordinary measure. So people will have their asylum claims considered in Rwanda under the pre-existing Rwanda policy that was announced by the previous Home Secretary, Priti Patel. Part of the way that it works is that clause 2 of the bill. So one of the sort of arcane parliamentary process things is that they're called clauses while it's a bill, then they become sections when it becomes an act. So clause 2, which will be section 2 once it becomes an act, imposes a duty on the Home Secretary to remove the asylum seekers to whom this bill applies. And in order for the bill to apply, 4 conditions have to be met. So a person has to have entered in breach of normal immigration laws. So, for example, if they require entry clearance, they didn't have it, that would apply to them. Or if they required leave to enter and they didn't have it, then it would apply to them. And that's essentially all asylum seekers who arrive to claim asylum, other than a very small number who might enter on, for example, a visit or a student visa without using deception. And then because of something that happens back at home, they then later claim asylum, some sort of change of circumstances, making them a surplus refugee. So use of deception would also bring you within this if you lie to get a visit visa or something like that. So basically entering in breach of normal immigration laws, entering or arriving after the 7th of March 2023, traveling through a safe third country, and also requiring leave to enter or remain but not having it. And such a person must be removed as soon as reasonably practical after the person's entry or arrival to the United Kingdom. There is a discretion not to remove those who are children in the meantime, but that discretion then lapses once the child turns 18, by which I mean it's a sort of slightly convoluted way of saying there's a duty to remove them once they've turned 18. There's also a duty to ignore their claims, and then in order to get round the problem that the bill creates of not assessing people's asylum claims, there's two separate lists of safe countries. Because the problem is that if you've got somebody who arrives from a country where some people get asylum, but not everybody. So say, for example, we know that 98% of people from Syria, I think it's 99% actually, people from Syria get asylum. But say, for example, you arrive from Albania or you arrive from Pakistan, countries where some people get asylum, but not all. They can't be removed back to their home country without their asylum claim being assessed because they might be persecuted. At least that's the normal way of thinking about these things. That's the normal way of understanding how the Refugee Convention and also the European Convention on Human Rights operates. So there's two lists of safe countries, and the first list of safe countries is basically EU countries, EEA countries, and also Albania. And people from those countries are removable back to their home country. So basically, if you are Albanian and you've got a decent asylum claim, the Home Secretary isn't allowed to look at that asylum claim and is under a duty to remove you either to your home country or to some other safe country on the third country list. That creates an immediate risk of Albanians in particular being basically refueled back to Albania, even though they have a good claim to refugee status. Now, that's not going to be all Albanians, but it is some. About half of Albanian claims in the past have been successful, although the cohort of people who are being considered is different to the cohort of people who've arrived in the last year or two, perhaps because of the delays in the asylum process. So it's a really big problem there immediately. There's a theoretical problem with people from other EU countries like Poland, for example, or from Hungary maybe, and from other EU countries if things were to go badly wrong there. But the main active problem is Albania at the moment. So that's the first list of safe countries, and it's going to be at the new amended Section 80AA of the 2002 Act. There's then a second list of safe countries, and this goes in the schedule to the bill. So this is going to become law as part of this act itself. And this is basically a list of countries which are considered to be safe, where anybody can be removed to. So if you claim asylum from Pakistan, for example, I mentioned earlier, you can't be removed back to Pakistan because you're not on that first list, but you can be removed to some other country. So you could be removed to Rwanda, for example. And it creates this extraordinary situation where even people who don't have good asylum claims, who, if their claims were considered, would be removable back to their home country, cannot be removed back to their home country because their asylum claim hasn't been considered, and therefore there's been no assessment of the danger that they might be in. And essentially, the Home Office is putting all of its eggs in one basket and saying, that's not a problem because we'll be able to remove all of these people to safe third countries. So it's a really extraordinary provision that essentially amounts to a de facto withdrawal from the Refugee Convention by refusing to consider asylum claims. Also, with the exception of EU countries and Albania not sending people back to face persecution in those countries, but instead sending them to some other country instead. Now, a lot of the attention that we've seen with the legislation has been focused on children, victims of modern slavery, and part of the logic of this bill is that if you create exceptions, then people will use them, and therefore there can't be any exceptions. So essentially, even victims of trafficking, accepted victims of trafficking, even unaccompanied children can be removed back to third countries, certainly once they've turned 18, but even potentially before that under this legislation, if it's practical to do so. And trafficking victims are denied the normal protection that they're entitled to under international law, normally under the European Convention Against Trafficking. So that's been effectively disapplied. Right, so that's my 10 minutes. That's my sort of quick run through of the logic of how the legislation is supposed to work. I think you can probably foresee that there might be some practical difficulties with that, which I've kind of headlined to some extent, but perhaps we can come back to those later if they're not covered by the other speakers. Thanks.
Thanks, Colin. Grim. Can I hand over to you, Anne?
Yes, thanks. I think my connection's a bit wonky, but I'll carry on. Thanks very much. I'm not going to cover what Colin's already said. Some of my comments are not informed by such a detail. But what I can say is that it seems to me that this is very deliberately not aimed just at small boat arrivals. It's not even just aimed at all migrants or just all potential asylum seekers. It's aimed at undermining the rule of law, and the danger for everyone in the UK is that this is an attack on democracy. If we just look at the numbers of people arriving, that's covered in one of the resources we've posted there. It's actually obviously a disproportionate introduction of legislation to address a problem. If I could say something about why I'm concerned about the rule of law, is that I see that this is not necessarily such a new move. It's just a sharpening and more vicious introduction of legislation. It's a continuum of the approach which is leading us down an authoritarian route, and attacks on civil liberties have been ongoing for many years now, and it's just accelerated. I think there are parallels with the European Union in that sense, so I would not expect that the EU and the UK are going to go into that much conflict, really, other than for performative reasons, because the kind of policies that produce harm at the borders are embedded within European Union policy. We've seen deaths at the borders in this last week accelerated in numbers, and terrible incidents on the US border with Mexico. The fatal journeys work that we've done, and the IOM logs in Missing Migrants project, as well as all the work that is done by NGOs to defend people over crossings, is all testament to the fact that this approach towards controlling migration by this kind of excessive force at borders is actually counterproductive. It doesn't actually, it's not a successful way of managing migration. And if we could say something perhaps about the question that you had about the role of academics, I think the political economy of migration research has much to answer for in the last 2-3 decades, in which migration has been conflated with integration policy issues and addressed in a kind of narrative that is really quite has undertows of racist and imperial legacy of the definition of the other in developing policy. So I think that migration scholars need to really wise up and step up to the plate now and say, this is not acceptable. I think the legal migration scholars, the lawyers, have done an excellent job in putting together the critiques very quickly, as Colin's just done, as we've seen in the link for the parliamentary inquiry. The work of Steve Pears has been very good on the European Union, and the work of State Watch that has highlighted and flagged up consistently the threat to civil liberties, what Tony Bunyan called the death by 1,000 cuts, and what Yasha Mechanico, who was a PhD student in Bristol, has investigated, is that if these attacks on migrants and refugees and asylum seekers are not addressed and attended to, then it becomes an attack on the whole population. So that we don't have an option to say this is something that we can put in that migration scholars can put in a box, and this is just about policy. It's about our responsibility as citizens of the United Kingdom, of the European Union, for people in the EU and human beings, to actually address the consequences of all of this. I think the attacks on the rule of law that I've just been trying to catch up with, listening to all the lawyers, include the conflation of what the problems with trying to get judicial review and due process in different aspects of appeal.
Sorry, Anne, you've just broken up.
For migration is, I think I've lost the connection. If the IOM, have I come back now?
You're back.
Yeah. I think we've got to a stage the International Organization for Migration and the UNHCR can put out public critiques and rebuffing the UK government on this bill, then it really important.
I know that I suspect that Anne was going to talk about the fact that both the IOM and the UNHCR have both criticised this bill, and that's actually quite a significant change. And I'm going to hand over to Andrew now because you keep cutting out. Andrew?
Hi, thanks. I should preface this by saying that political opinions here are mine rather than Bristol refugee rights, if I make any. I want to start by saying I think there's two ways to look at this bill. You can look at it on its own terms as an attempt to fix a broken system, that's what it claims to be, or deter new arrivals, or as a political weapon. For a bit of background, there can't be any doubt that the asylum system is broken. The backlogs are huge. People spend years waiting in initial accommodation settings, hotels and barracks. The legal aid shortage is chronic. People, they really are stuck in a system that serves nobody's needs. The experience of that for asylum seekers is a kind of painful limbo filled with uncertainty. People talk at Bristol Refugee Rights about how time moves differently whilst they're waiting in IA settings, a kind of existential change in your experience whilst you're waiting. And then by the time they get their leave, they're squashed by this experience. Inadmissibility, third country removal, other changes in the Nationality and Borders Act and the wider asylum system have all kind of made this worse. People talk about rumours around Rwanda running riot around hotels. We've met people who've left those hotels and chose to sleep on the street because they see them as sort of waiting rooms for Rwanda flights. Even the questionnaires that were brought in have introduced a kind of sense of panic and unfairness. And this idea of the Group 2 refugees in the Borders Act will no doubt kind of worsen that when settlement becomes so much harder and people can't build lives once they have got their papers. So with that context, how does this bill fare as an attempt to fix that system? Well, as Colin and Anne have said, it's not an attempt really to do that. It's an attempt to avoid having an asylum system at all. Just to repeat really what's already been said, almost all asylum seekers currently arriving by means that the proposed laws would make illegal, and therefore there would be a duty to remove them from the country and not even consider their claims here. So even if this was a good idea, which it's not, it's obviously not a good idea, it's unfair, it's illegal, it's being condemned by any sensible person internationally, there aren't any means to do it. Despite our extensive, overly massive detention estate, the physical space to detain people isn't there. Whatever agreement has been reached with Rwanda can't extend to all this numbers of people, and there aren't workable agreements with any other safe third countries now that we're out of the EU. And the courts are already backlogged. The time it would take to process it's already taken to process appeals against these things is surely just untenable as a solution to this problem. So the impacts surely can only be an exacerbation really of the existing problems in the asylum system, even greater uncertainty, even longer delays, even more people trapped in these kind of prison-like times in their lives, and an even greater sense of being unwelcome, a hostile, racist environment, and the difficulty that will make for anybody trying to build a life in the UK. Another possible or likely implication is an increased use of more clandestine means to enter the UK rather than small boats, which are quite open. I was in a sort of surreal meeting with some people from the Home Office where they were talking about this risk and how aware they are of it and how difficult it's going to be to manage the increased risks of trafficking, exploitation and illegal working, because that will be a possible consequence is that people want to hide from this system. So it doesn't fare well as an attempt to fix the problems that do exist in the asylum system. The other way that I mentioned this bill could be assessed is as a political weapon, which I think is more likely what it really is. It's been a theme in immigration policy to include bold, inflammatory language for quite a long time now. And increasingly, the claims that are made in policies just can't be implemented. And in quite a lot of cases, no real attempt is made to do so. So in the Immigration Act in 2014, there was a provision that would allow local authorities to make families with children homeless, which would normally be illegal under the Children's Act. But it was never really implemented. It was just there as a big racist flag to wave to make people feel scared. And I think this is a tactic in the culture war. Say something outrageous and dare your opponent to question it. And I think it's on this basis really that the bill may prove most effective. So people who are afraid, politicians who are afraid of looking kind of weak on immigration will acquiesce and further legitimize this kind of demonizing approach to the question of migration and asylum. And then people who do question the bill not only risk the wrath of the media, vast swathes of social media, but they also keep the issues in the headlines, giving more air to these people who monger hate. That being said, we can't stop talking about what a fair immigration system might look like. And I think that's where the role of academia can be in this, is that we desperately do need a fair and effective approach to people crossing borders. People will always move. And as the world heats up, that's only likely to increase. So we can't ignore the question and we can't pretend that we can just offshore it somewhere else. So yeah, to my mind, that's the best way to challenge this bill. Politicians who would oppose it need to get serious with policy alternatives. They can't just confirm or deny whether they would continue with Rwanda flights under a different government. What's needed is a serious, joined up approach which addresses insecurity and structural inequality around the world and at home. Take seriously our commitment to providing sanctuary from persecution, and also our need to manage the movement of other people across borders for other reasons. Like this isn't how we have to approach migration. As an example, the Homes for Ukraine scheme and the Hong Kong British nationals overseas visas have allowed significantly larger numbers of people to settle in the UK than have claimed asylum in the past year or so. And it's barely made a splash in the political ocean. And when it has, it's usually been received well. So there's no need to treat asylum seekers differently. It's just a political choice. That's me.
Thanks, Andrew. I mean, one of the things that struck me when I was looking at the explanatory notes to the bill was, and then also listening to some of the kind of political debates, is that you have the rising numbers of people in so-called small boats, and then the rising costs of asylum. So those two are put together. Clause 9 and clause 10, I think, of the explanatory notes, as if they're connected, as if the rising cost of the asylum system is because there are more and more people coming. But I mean, there is the asylum system is broken. The fact that people are now being housed in hotels is not the fault of the asylum seekers. So I think that kind of, yes, thinking, sort of disrupting some of that logic is really important. And I also think that it's important, I think you're right about the kind of efforts to silence and the importance of being brave, actually. And I think that, in terms of looking forward, we have to think, well, not only is there a problem with the bill, but there's also already going to be problems with the already consequences of the bill. So the fact that people from the 7th of March are going to be, irregularized with no route to, any possibility of legal status. But also what happens if there are flights to Rwanda and you have Afghans dumped in Rwanda, what are they going to be left in Rwanda after we've, imaginally repealed the bill? this is such a sort of injustice of such huge proportions. I think we really need to be kind of trying to mitigate the consequences of it, though I do think that Colin in Colin's podcast, you know, he was talking about the violence of removals, you know, and really the risk that we're going to see really kind of an increase in violence in violent removals and what that means for people on the sharp end of it. Anyway, thank you, everyone. I'm just going to take a quick look at the questions. So on the bill and the bill and its implications, so there's a couple of people who are interested in the implications for refugees and migrants who are already in the UK, including, so I suppose we have to think before and after March the 7th, because March the 7th is obviously a kind of key cutoff date because of the retrospective nature of the bill. But so what are the potential implications for refugees and migrants in terms of employment and economic opportunity? I don't know if you want to go first on that, Colin.
I'm not sure what to say. The people who had already arrived before the 7th of March are subject to the existing inadmissibility process and so on. So the idea is that under the existing law and the 2022 legislation, they would have their claims paused while the Home Office investigated removing them somewhere else. My suspicion is that the Home Office is just going to give up on that because they're going to focus on people who've arrived after the 7th of March. And if we think through how this is going to work in practice, insofar as it does work in practice at all, basically probably tens of thousands of people will have arrived between the 7th of March and this act becoming law. It's only a relatively small number who've arrived from the 7th of March so far because the weather's been bad. But, you know, over time, those numbers are going to build up. So there's going to be a cohort of people who've arrived between the 7th of March and the bill actually becoming law. And then the Home Secretary is going to be under a duty to remove those people to Rwanda, but will also be under a duty to remove anybody who's arriving from when the bills become law as well. And how they're going to use their resources to try and detain and remove these people, I just don't know. My guess is their focus will be on trying to detain everybody who arrives from that day onwards, assuming they've built detention camps that are capable of holding them, and then they'll try and start rounding up people who've already arrived previously. And basically the people who've arrived before the 7th of March 2023 will be the bottom sort of priority for the Home Office. So in theory, those people could still be removed to Rwanda, but I think the Home Office is going to have its hands full trying to enact its horrible policies for the people who've arrived since then, which is going to be a virtually impossible task anyway. But of course, they're not only subject to this inadmissibility process, which is a kind of formal process, they're also subject to just total breakdown in Home Office decision making. So I think they will eventually get asylum decisions, but it could be years down the line. And the backlog is still growing. So there's been all this stuff about recruiting new staff. They've doubled the number of staff at the Home Office already. They're planning on doubling it again. This is in the Asylum Casework Directorate. But as far as we know, last time the statistics were published, the backlog was actually still going up. So they haven't even started reducing it at all, never mind making really serious inroads into it. So people will be stuck in limbo for some protracted period of time, basically looking forwards. But probably the date that really matters is arrive before the 7th of March. Probably there's some sort of route to status for you in the long run. But arrive after the 7th of March, and according to this bill, you can never be granted status, and you'll be removed to Rwanda.
I suppose also the question is you have to prove whether you entered before or after the 7th of March, which also in itself could be not easy if you entered irregularly. Andrew, do you have any sort of comments on it from a sort of frontline point of view?
I mean, I think that the experience of people who have arrived in this whole period since the discussions of Rwanda started becoming, well, like, widely discussed, has been one of kind of confusion, paranoia, and uncertainty about the future. So if we're all confused about what this bill means, then the people who it might be impacting on will be even more so, and will be hearing second and third hand, half translated information about it. And I think that initial accommodation settings are quite fearful places to live. Sometimes people hear on the grapevine that things are changing in the system to make it harder, and so that I think is the non-legal impact of this bill, is that it just increases that sense of fear and uncertainty, and of not being legitimate as a person, really, in the UK.
Okay, so now I'm going to pull together 3 questions, and then I'll go around and ask each of you to kind of respond to one or all of them. So firstly, can you say anything more about the implications for modern slavery and the national referral mechanism? So that's one question. Another question is, from a legal perspective, doesn't this conflict with conventions the UK is signed up to, and is the bill itself legal? And then the final question, what do you think is the potential political and social impact of the Prime Minister advertising this as part of work against antisocial behaviour? So perhaps, can you think about the more general context implications of this bill? So maybe I'll start with Anne, hoping you don't drop out.
Yeah, I hope I stay in. I think the context of looking at modern slavery, if we put that in the broader context of the labour market and exploitation and precarious employment, it's very dangerous for everyone in that precarious labour market. But I think also thinking about modern slavery as a very epitome of what the bill says people will not be protected from, the very people who are the most vulnerable in the system who actually need that protection. So it's such a vicious piece of legislation, because it's attacking the people who need protection the most. So it's the people in those precarious jobs, children, people with disabilities, people who have come from immediate conflict zones, and the people who've been rendered vulnerable by the system, by being lost in the system. So if we just divert a bit on that, I think what's happened is it's created a market and an investment opportunity for people who can invest in the detention estate through their mates. And what's happened with the pandemic, we've seen this lack of due process in handing out contracts. There's a lot of money to be made in locking people up. And I think that's part behind the scenes, the big smoke screen about things that may be challengeable and not happen. It's actually covering up another kind of money grab and power grab going on behind the scenes. So I'm worried about all of that. I think on terms of what can be done positively, I think we need to say, if academics need to propose a positive way in looking at the contribution of people to the labour market, take people out of modern slavery, because the working conditions are protected for everyone. So you have proper regulation of employment, and that we need to, as academics, work very closely with NGOs, civil society, social enterprises, to say, use that combination of what Fuad Mohammed will say is the lived and the learned experience, to combine forces to actually produce the positive message, to change the narrative that we need to do to confront all of this. So I think I'll hand over to Colin or Andrew now. Thanks.
Andrew?
Could you remind me what the second 2 questions were?
Yeah, sorry, it was a bit of a blast. So the second 2 questions were about is the bill itself illegal? And what about international conventions? But I think maybe more for you, the impact of the way that this bill is being talked about by politicians and by the government.
Colin's probably better to speak about whether it's legal or not. You know, if it feels, doesn't it, like it couldn't possibly be. I mean, it feels like it's in direct contravention of national conventions. But yeah, Colin's much more expert on the law. I think the impact of the way that politicians talk about this bill is quite stark, really. I mean, it used to, one thing that struck me yesterday at a talk that we did here at Bristol Refugee Rights is the way in which it used to be a big part of the migrants' rights campaigning to say, well, there's no such thing as an illegal asylum seeker. And that was a kind of pushback against that whole bogus asylum seeker narrative. And what this bill does is actually means that there would be such a thing as an illegal asylum seeker, and it would be almost all of them. And we sort of lose that power of saying, well, under the actual law as it stands, there's no such thing. We still need to be careful about our language and be challenging that language and be resisting the idea that people are somehow illegal. I think Anne said at the beginning about it's not the people that are illegal, it's the system that illegalizes them. But that is what this bill does, is it illegalizes a vast swathe of people who actually need protection rather than increased vilification. And I think, as I said earlier, I mean, the nature of the political context that we are in, of this really rampant culture war approach that is kind of being used by the current government to, well, to try and win elections despite having made so many mistakes, to try and pass off their own failures as other people's. The use of language like that in such a way as to make it difficult for us on the left or on the side of the people who are needing support just makes it very difficult to defend the things that we believe in, because when we do so, we buy into a really inflammatory discussion that is quite hard to control when people are willing to say such kind of outrageous things about other people.
I mean, I think in relation to that, one thing to pick up on in the bill, and I don't know if you have any comment on this, Colin, is this category of an ineligible person. And which I think is quite a frightening kind of categorization, quite alarming terminology. And I don't know if that's, to your knowledge, has that been used before? Is that idea of an ineligible person something that anyone has heard of before? And if so, are we going to have to start sort of shouting, no one is ineligible?
That's an interesting one, because I tend to be a bit focused on the law, because I'm a lawyer, and ineligible is not a particularly offensive phrase. You know, there's plenty of people who are ineligible for certain things, although I suppose, you know, it's a point you've made with your work previously, Bridget, you know, it's often to do with benefits and entitlements and things like that. But before I go on to the legal ones, on the sort of wider point, one of the interesting campaigns in recent years, I think, has been the right to work campaign for asylum seekers. And I've got really mixed feelings about it, because on the one hand, I've never thought the Home Office was ever going to concede that ground, essentially. It's considered to be too much of what they call a pull factor. And on top of that, I don't really think the right to work is that important when it comes down to it. If you're getting a rapid decision on your asylum claim, you know, rather than filling around with right to work, I'd say focus on getting swift asylum decisions. And then on top of that, I'm also concerned that, you know, if you if people do get the right to work, that can be used as a justification for penalising those who don't, and saying they not just have a right to work, but they should work as well. And there are plenty of some. So that's not to say that's not the right campaign, because it kind of humanizes people. It gives refugees agency. It makes a wider point about the fact that they can make a positive contribution to society. But it's really complicated, and there's no clear right or wrong answer to my mind to a lot of these issues. They're just really complicated and messy, and there's no kind of ideal, essentially. But coming back to the legal questions, there was one on modern slavery. The position with the bill is that it doesn't stop somebody from putting forward a claim to be a victim of trafficking or modern slavery. What it does is it says that it doesn't matter. So in theory, you would put forward your claim, or that's not even how it works. You get identified. You don't put forward your claim yourself in a way. It gets put forward for you by first responder, usually by the Home Office, and they will still, in theory, assess whether you are a victim of trafficking or modern slavery. But in the meantime, they're under a duty to remove you anyway. And also, even if they do recognise you, they will deny you the 30 days minimum of I can't remember what they call it, the rest and reflection or rest and recuperation period that you're supposed to get according to ECAT, the European Convention Against Trafficking. And there's a really dodgy argument in international law terms that the Home Office is using to say, oh, we don't have to give that to people because there is a public disorder, public order exemption to it. Whereas, any lawyer would say, well, that's not about a general situation of too many people coming into the UK or whatever country. It's got to be focused on their own risk of creating a public order problem. And that leads on to the sort of second question, which is about compatibility with international law. And this is the difference between being a practicing lawyer and an academic lawyer, because an academic lawyer can happily say this is unlawful and leave it at that, whereas a practicing lawyer has to say, well, yeah, it might be unlawful, but so what? Because rights just do not count for something with a government like we've got unless there's some sort of enforcement mechanism, unless you can force the recognition of your rights and have the basically have a court to go to ensure that they're enforced. And there isn't a court to do these things with international law, generally speaking. There is no international court of refugees built into the Refugee Convention. So UNHCR can huff and puff as much as they like. They can't do anything about it. They've got no enforcement mechanism, and it's that's the problem with the Refugee Convention. Is it's just not a robust legal instrument from an enforcement point of view. So I'd absolutely agree that it is obviously incompatible with the kind of spirit, the intention of the Refugee Convention, even with the letter of some parts of the Refugee Convention. But that just doesn't count for anything with a government like this, unless you've got a way of enforcing it, and we just don't. We probably just don't. There are more serious problems with the human rights stuff. And the idea that you can be sent to a completely different third country that you've got no connection to, and that's not a breach of your human rights, may seem surprising, but human rights protections are really minimal when it comes down to it. They don't, generally speaking, give you a right to status in a country, and all they do is prevent you from experiencing certain things. And basically being sent to Rwanda, unless the Rwandan government starts mistreating people quite badly, which they may well do, that may happen in the future, but it's speculative at this point in time. It hasn't happened so far, and we can't prove it's happening at the moment because we're not sending people there. Unless and until that starts happening, then it doesn't look like it's an obvious breach of somebody's human rights to be sent there. And then on top of that, one of the things, the bits of detail that I didn't go into earlier, there is a mechanism by which a person can say, well, it is a breach of my human rights to be sent to Rwanda. So say, for example, you're receiving medical treatment in the UK that isn't available in Rwanda, or say, for example, you've got family here in the UK, you've got a spouse and children in the UK, and you say that will breach your family life if you get sent to Rwanda. And the way the bill is supposed to operate is you have a short period of time to make what the Home Office calls a serious irreversible harm challenge. there's a very abbreviated appeal process that has to be concluded within 28 days normally. And your argument would be, well, look, I can't be sent to Rwanda pending the outcome of my human rights claim because it would cause me serious irreversible harm. And the Home Office will be saying, well, it's a bit early to say, we'll look at your human rights claim in due course. They're famous words that they use a lot at the moment about impact assessments and various other things. You know, the Afghan scheme will be open in due course and so on. 2 years later, it's still not. But they say, well, look, well, if you've got a good human rights claim, we'll grant it and we'll bring you back. So this serious irreversible harm thing is just about what happens to you in the meantime. So there is this kind of protective mechanism to some extent built into it, which is why, you know, a lot of us are saying it's quite tightly framed. It's quite internally cohesive. It's quite difficult to challenge in domestic law. And it is very difficult to challenge in international law because it's really hard to get your hook into it to found a legal challenge on, essentially, to go to a judge and say, this is unlawful and it's in breach of this binding law, and therefore you've got to allow this case. It's really hard to see how that's going to happen in practice.
Thanks, Colin. Just before we were starting, Colin and I were chatting, and I tried to run past him the idea that maybe Ecuador could take a case against under the UN Convention against the UK government. Let's see, but that's a long haul. There's lots of other really great questions on the bill and its implications, but in the interest of time, because I do want to sort of touch briefly on what can be done. So I'm going to turn to the questions and comments in that section now. So fingers on the buzzers, please, panel. So I'll just again give you sort of 3 questions that come from the people who are present. So there's a kind of set of questions about potential avenues to challenge the bill and also the act. So do you have any advice on the public and third sector? You know, what advice do you have to offer? And there's kind of relatedly, there's some kind of thoughts about how to build solidarity with other marginalized groups. So, you know, what kinds of allies can we look for? And again, I don't think this is just a question for the panelists, because, you know, there's no reason that they should be expert in this any more than any of us are. But if you have any thoughts on that from the panel, then please, could you let us know? And yeah, how can we, so I think I'll just leave it there because we've only got 5 more minutes. So Anne.
Yeah, thanks. I think we need an organised, transparent and public, very wide campaign around civil liberties in general, the attack on civil liberties and human rights for the whole population. And within that the implications of this bill are one part and one example, but not to, I mean, we also need to combine and show solidarity in anti-deportation campaigns and the activism that can be shown across the civil society sector. But I think we need to take the charge really to say we need a new narrative on civil liberties. We need to combine and support each other in saying human rights and civil liberties are under attack for everyone, and this is a threat to democracy in the UK. So there are various discussions going on about how we might address that. It should involve everyone, the churches, the trade unions, civil society groups, academics, and not be left, it should not be left to the smaller organisations delivering services to the people who are the most vulnerable. I think everyone has to step up to the plate here. So that's my appeal for a kind of leadership on those issues and working in solidarity together, and to show as well, to change the narrative to a positive one in which we can say that the dynamism and the human mobility actually brings richness and diversity to human society, whichever country we're in, and it's something to all of our benefit that we go ahead and look in a positive way at migration and mobility.
Thanks, Anne. Andrew, I suppose also, you know, coming from Bristol Refugee Rights, you know, are there things that people can do to support you and the people that you work with directly in the context of this bill?
I was just going to say something first about the bill stage of this before it becomes the act. And to my mind, given what Colin said about the kind of legal difficulties of challenging the bill, the obvious weak point surely is the unworkability of this bill. It's hard, it's hard to see how any serious legislator, whether they're in the Commons or the Lords, could look at this and think, oh, that works. The Nationality and Borders Act didn't place this kind of duty to implement the removal in the way that this does so widely, and the impossibility of that seems like such an obvious flaw for anybody who's got kind of half an eye on what it might be like to implement this as law. And surely that must be a weak point for at least some of our representatives in the Houses of Parliament. In terms of like practical support that people could offer to organisations like Bristol Refugee Rights, I mean, okay, our biggest challenge coming up is funding. I mean, the political, the funding environment for third sector organisations in general is stark. And so I imagine that not just Bristol Refugee Rights, but organisations like us around the country will be thinking, how are we going to fund our advice services? How are we going to fund our food banks? How are we going to fund our English classes and the travel for people to get to those places? So I wish I could say something more radical, but cash would be great.
Point taken. Thanks, Andrew. Colin.
Yeah, I think my message is a slightly depressing one in some ways, which is don't pin your hopes on the law, don't pin your hopes on judges. And there are two reasons for that. One is because the law isn't really a very good means of challenging these kinds of things. And lawyers will do what we can to challenge individual decisions where somebody has got a really outrageously good claim. We might be able to stop them from being put on a flight to Rwanda, although we won't be able to get them status in this country. So we'll challenge it as far as we can. But that's kind of, in some ways, it's the wrong question. That's no good for building a political movement or for changing public opinion more generally. And to go back over just what Andrew's been saying, if you compare the level of funding in the sort of civil society sector in this country to what goes on in the United States and so on, it's just derisory. There needs to be a lot more money, frankly, going into civil society than is currently the case. And it's not that money is some sort of simple magic answer. It also has to be well used and put to good use. But yeah, and don't pin your hopes on law and the courts. Sorry, I said two reasons. I forgot the second reason. The second reason is that that's what they want. And it doesn't mean that we won't bring legal challenges, but they want to be stopped by the judges. I think they must realise that this is a completely impractical, impossible bill, that it's a disaster either way for the government, that if they start actually removing people to Rwanda, it will be horrible. People will die. It will be violent. There will be huge detention camps. And if they don't, then there's going to be thousands and thousands of people here with no status, begging on the streets because they're not willing to hang around waiting to be removed to Rwanda, as a remote a prospect as it might be. So they want it to be challenged in the courts, and they want to be able to turn around and say, well, we would have solved this problem if it weren't for these pesky judges and lawyers and so on. So that's not to say that we won't be trying to bring challenges, but that is not some sort of good answer to what's going on at the moment.
Yeah, I think really we do have to start with what some of the people in the comments have been saying about the importance of building solidarities and new relationships with people outside the sector as well. Well, thank you very much. Thank you very much for your input. We could talk about this much longer. Thank you everyone for coming. Do take a look at the resources on the website, and we will be following this up with some blogs. So and if there's any comments, any ideas that you have that you want to explore with me or other MMB members in relation to this bill, then please get in touch. Thank you very much, everyone. Thanks, Colin, Andrew, and Anne, and Emma and Emily behind the scenes. Thanks. Bye-bye.